Albie, good morning, everybody. Very warm welcome to you on this particular webinar. We're talking about POPI, the TES client candidate dynamics. As Albie mentioned, this is becoming increasingly more important as we move deeper and deeper into the fourth industrial revolution. We, I believe, on the cusp of the fifth industrial revolution. And we see that the first fines have been issued in respect of breaches of POPI. That's after the information regulator decided that the Department of Justice was not bringing its side in respect of its compliance order. You'll remember the Department of Justice was subject to a cyber attack. They were lacking in a number of areas. The regulator instructed them to close those gaps, and they failed to do that. 5 million rand fine. That's the first fine that we know of that was issued in this regard. So up until now, the information regulator has been fairly collaborative and wanting to capacitate and empower, but you can be rest assured they are becoming more enforcement focused. They've also just arrived at companies. I know, for example, they arrived at, I think it was Nedbank, just out of the blue, unannounced, and they also arrived at Netflorist a few weeks ago off the back of complaints by public in respect of the way Netflorist was dealing with their personal information. So I'm going to take you through, colleagues, a very quick overview of the POPI Act. I'm going to try and contextualize it in the context of TESs in particular. And what I'd really want to encourage you to do is to immerse yourself in this session. We won't be busy for very long, but just think of your daily environment. Think of your daily activities when it comes to processing personal information, and hopefully you'll identify areas for improvement, maybe areas you hadn't yet thought of. And obviously, your questions and comments are most welcome. You can post them in the chat box, and I'll also open up for Q&A at the back end of this. So with that in mind, let's get cracking. So, colleagues, the process I'm going to follow is starting off by looking at the world in which we find ourselves, the world we live in, just to contextualize the gravity of the issue of POPI. We're then going to look at the core principles of POPI in terms of what is considered to be personal information. I'll be referred to things such as medicals, etc. And then secondly, we're going to be taking a look at, from the TES point of view, what are some of the framework and the landscape areas when it comes to POPI. We'll then bring it into the world of TES specifically, and I will share with you just some of my thoughts based on key touch points that you need to ensure that you've covered when it comes to POPI. And then we'll open up for Q&A. Krista has got the slides, so don't worry about taking any notes or whatever the case may be. You will get the slide deck. I think use the opportunity to really just focus on, as I said, enhancing your knowledge and identifying areas that potentially you need to improve in. Well, colleagues, we know the world we live in is irreversibly disrupted. The world we live in is characterized by data, information, systems, platforms, applications, and the like. And as a result of this, the way in which our operating models manifest means that they are incredibly focused on what we would say the processing of personal information. We just take a look at the rate of change, and many of you would be aware of this, that, for example, the rate of change is of such a nature that the traditional bell curve has been replaced by the shark fin curve, where things change and consumer behavior migrates so quickly. When things happen, they happen exponentially. So it took 3.5 years for Netflix to get to 1 million online users. And it took literally, colleagues, it literally took 4 days or 5 days rather, to get 1 million people onto ChatGPT. And the reason I'm highlighting this is the rate of change is just so significant that if your systems, your security protocols, and your enterprise architecture is not contained, if it's not properly secured and managed, and if your staff members don't have a culture that speaks to the protection of personal information, things can go drastically wrong very, very quickly. Especially if we look at the most common types, colleagues, of cyber attacks. These are 4 that are listed on the bottom right-hand side. Structured query language injection attack is when, in this type of attack, hackers write vindictive code and really insert it into your database. And as a result of that, this code accesses personal information. Then you get man in the middle. That's the second most common type of attack, where someone hacks into your communication between yourselves and maybe your clients, or yourselves and your assignees or job applicants. And what happens is they eavesdrop, they pick up the gist of your conversation, and then they pose as one of those parties. And by doing that, they can access very, very sensitive information. Then you get phishing, which we're very familiar with, where cyber criminals pose as legitimate institutions like banks, maybe like your clients, maybe your suppliers, where they, pose and prance around as if they are, and they can gain very important information and even get you to pay money into vast sums of money into the wrong banking accounts. Then you get the denial of service attack, where your systems are just flooded with traffic and your network becomes inaccessible. Now, colleagues, the reason I'm sharing this with you is, again, just to illustrate how quickly things can go wrong and the extent of that. If you just take a look in South Africa, Experian had 23.4 million data subjects information that was compromised. We then see Transnet being literally incapacitated as a business for, I think it was just more than a week, when their operating systems were subject to attack, and a lot of containers and ships could not be mobilized and demobilized in terms of this. Personal records also view fines. If you pay fines on view fines, chances are your records were compromised. 943,000 people's records, and then Facebook also being subject to this. And what's quite amazing, colleagues, is, you see some very, very high-profile names. You see Statkinnicor, you see Transnet, you see Department of Justice, you see Virgin Active. These are companies and organizations that have got the resources to have very, very meaningful systems and operations and platforms that can, really be protected. But you see, they, notwithstanding that, they are subject to this. Now, just to remind you, the 1st of July was the date of promulgation of the POPI Act. Companies had 12 months till the 1st of July 2021. So effectively, more than 2 years ago, almost 2.5 years ago, the POPI Act became of full force and effect. And what's very concerning is when we see this, organizations are treating it as an event rather than as a journey. There was a lot of activity initially, and from what I see, people and companies have become complacent, and they're going to be opening themselves to risk. This research was done across the world, but if you look at South Africa's response, it seems that 7 in 10 organizations will be hit by cyber attacks in the next 12 months. It's a 70% chance. And even, as I said, some of the companies with the best types of protection, the best cybersecurity, have been attacked. 75% had up-to-date protections, and 38% of the cyber attacks were in the form of ransomware, obviously where organizations need to pay often tens of millions of dollars to try and get access to their data and to keep functioning. The big challenge here is if you look at what's happening in organizations, most of them say that they lack a decent cybersecurity budget. So if I was to say to you today, what is your allocated budget for cybersecurity? What would it be? What percentage of your turnover would it be? Or is it really just an afterthought and a grudge spend? It's really, colleagues, should be one of the top 5 aspects on your risk registers. So I wanted to impress on you the world that we live in and how quickly it can bring entire organizations to their knees, and of course at great expense. Well, let's take a look before we go into some of the detail of the POPI Act. Let's look at POPI in the context of TESs. So if we look at the far left, we see that the POPI Act requires effectively 3 dimensions of response. The first one, colleagues, is the proactive interventions, the things that you can do to mitigate the probability of you and your organization being subject to a breach of data. So the proactive activities would include having very good policies, including privacy policies, POPI policies in your various commercial documents, your employment documents, and I'll go into a bit more detail on that. But you need to have the policies that create the regulatory framework and the protocols in the industry in your organization. The next thing is to create awareness. So by being proactive, you'll see the POPI Act doesn't suggest it, it instructs you that you need to create continuous awareness of the need to protect personal information. And I'm going to talk to you just now about the awareness scope, because you've got a lot of stakeholders in your environment. Then you need to do an impact assessment. You need to look at all the key business processes, the platforms, the systems that you use, and you need to make sure that they are secure. You need to put the safeguards in place in terms of your technological and your operational safeguards. And very importantly, you need to identify operators. And I'm going to spend quite a bit of time at the end of this talking about operators in your environment and what an operator is. Because if you have an operator operating and providing services to you, by law, you have to have a written POPI agreement with them. Once you've covered the proactive and preventative measures, the next thing is, of course, to ensure the security both of your technology and your people. So technology security will include data backup, endpoint protection, advanced security, encryptions, network perimeter security, all those technological protections. But then equally important is your human component, because it's the people that are often, not capacitated and not given the awareness to identify threats. They then click on emails or attachments that they shouldn't be clicking on. The next minute, you find you've spammed thousands of your clients or you've compromised your security. So you need to implement that security framework that gives you an additional layer of protection over your proactive steps. And then, of course, we see that 70% of companies get impacted by some form of breach of security. And that is when you need to be very, very responsive. I should actually change that word to responsive, because if something goes wrong, colleagues, you need to know exactly what to do. The POPI Act's very clear in terms of how you need to respond if there's a breach. And we will take a look at some of that detail. So these are the 3 dimensions, and I will challenge you today to look at your organization and to say, to what extent have we covered all 3 of these dimensions? Now, as a temporary employment services, the POPI Act refers to you as a responsible party. In other words, you are responsible for the personal information of your data subjects. And as a result of that, you have appointed an information officer and registered that information officer with the regulator. And that is an incredibly important appointment. That information officer not only is has jurisdiction over POPI, but also the Promotion of Access to Information Act, the PIA Act. But the information officer is really responsible for the responsible parties' operationalization of POPI. I also have added in the need for an incident response team. Remember, I said over here, if something goes wrong and you suffer some form of breach of security, then your incident response team needs to immediately kick into action. And that team then has got certain protocols that need to be followed in terms of advising the regulator, advising the data subjects, and then, of course, taking the necessary steps to prevent further loss or damage of information. Then on the far right-hand side, colleagues, you have your data subjects. In other words, these are the parties, be they legal entities or natural people. These are the parties that you secure and source your personal information from. So your applicants for employment. I mean, just think of the volumes and volumes and volumes of personal information that your applicants for employment give you. And before I forget about it, I want to ask you the following question. How long do you keep this information for? Very important, because you'll see just now the POPI Act says you cannot keep this data indefinitely. You can only keep it for as long as the law requires it, or as long as you can justifiably keep it, or then you've got to de-identify or destroy that information. So your applicants for employment are data subjects. Your employees are data subjects. Your current clients, your prospective clients, your current suppliers, your prospective suppliers, your operators, and we're going to talk about them, as I said, later on, and then other. Colleagues, many of you do a lot of work on maybe socioeconomic development or CSI. You may do outreaches or community projects and take photos of people, and maybe you go to schools and take photos of kids under the age of 18. And there's certain requirements legally before you are allowed to process that information. So don't narrow your data subject scope. Think of the broader data subjects whose information you may also be bringing into your environment. So this is a POPI framework for TES. This is the world in which you operate. And the question then is, how well are you performing in respect of this ecosystem? How secure is the information of these data subjects? Well, very, very quickly, I want to talk about the information officers of temporary employment services. So if you are the unfortunate winner of being appointed information officer of your business, well, let's just recap the 5 things that would be your key performance areas. These 5 things are prescribed by law, colleagues. This is not the world according to LB or John or Krista or anyone. This is the POPI Act. The first thing, you need to develop a compliance framework, but not only develop, you've got to implement, monitor, and maintain it. So you might say, but John, what is a compliance framework? Well, there we've just seen it, colleagues. You need to have a compliance framework that speaks to each and every one of these components on the screen right now. So if you don't have a framework that regulates the processing of these data subjects' personal information, if you don't have an incident response team, obviously, if you don't have an information officer, if you don't have security measures in place, and if you haven't done all of these proactive measures, colleagues, then you're going to be falling short of your obligations. And as a result of that, you could also have collateral damage. Your clients are going to lose faith in you. your integrity, and of course, your data subjects. So very quickly, reputational damage as well can be a big issue. The second thing the information officer of the TES must do is conduct an impact assessment. In other words, you need to look at this framework and you need to say, well, what have we done and what do we need to do to improve on what we see in front of us? For example, do your employees use their cell phones for emails, WhatsApp groups related to the workplace, or their cell phones to communicate with clients and assignees? And if they do, the question is, do you have a bring your own device policy? What do you do in terms of that data? What if someone's, laptop is stolen out of their car? Are their laptops encrypted? Are username password protocols embedded into your daily routines? So you need to do regular impact assessments. The next one is point C. You need to ensure you also have a Section 51 Promotion of Access to Information Act manual. In other words, third parties that want access to information that you hold, those third parties need to be able to go onto your website, download your manual, and then have an application form which is prescribed to request certain types of information, and then you've got certain time periods within which to respond. Point D, information officers need to speak to the data subjects. In other words, they need to process requests for personal information. Colleagues, one of the big challenges that these data subjects face is, let's say that one of the data subjects want to speak to the information officer. So maybe they're not happy with the way in which you're processing the information. Maybe they're being spammed by you. Maybe they want to unsubscribe from your mailers. Maybe they don't want you to keep any of their data anymore. They need to be able to get hold of the information officer. And if they can't get hold of the information officer, guess what? They're going to go straight to the regulator. And the more complaints the regulator gets, the more probability will be of the information regulator pitching up at your workplace and doing an assessment and an audit. So you want your data subjects to easily be able to get hold of the information officer. And I'm quickly going to show you an example of how to achieve that. And then the last one, internal awareness sessions. And that's why I said in this framework, part of your proactive legal obligations are to do awareness creation sessions. Now, who do you create awareness with? And I want to plant a bit of a seed and say, what about your assignees? To what extent, when you do induction, do you not only cover health and safety, harassment, but also POPI? To what extent do the assignees you place on your client's premises, to what extent are you able to at least create an awareness, because they will be dealing with personal information of your client. They'll be dealing with personal information of your colleagues. So you need to be sure that your assignees are also very, very aware of this. So what I'm quickly going to do, colleagues, is I've unshared. So if you think that you have maybe lost connectivity, don't worry about that. The reason is I want to show you very quickly an example of data subject participation. In other words, how should data subjects be able to immerse themselves in the world of POPI in your organization? So I'm going to just show you, and you should be able to see on the screen our website. So let's say you were one of our clients and you were not happy with receiving our mailers all the time. That's driving you crazy, right? And now you want to get hold of me, the information officer. And so what you do is you go to our landing page on our website and you go down to POPI and PIO. So you click on that. Immediately you will see protection of personal information. And there you will see, I am the unfortunate information officer of Global Business Solutions. Cynthia is a deputy, as is one or two of the other colleagues. So there's our registration certificate. So the first thing is you satisfied that we are compliant thus far. You then click through, and now what you see is my details. You see my email address, my cell phone number, and our contact details. You can then also take a look at our Promotion of Access to Information Act manual, a form if you want to access information from us. And just by the way, these forms were recently updated, so you need to go and double check that you've got the very latest forms on your website. And then there's our privacy policy, and I'm going to come back to that later on. The privacy policy is very important. Then what you can do is you can then click on whatever it is you want to do. So if you say you want to us to no longer use your data, well, then you'll click on that and submit the email with your particular complaint or your request. If you want to object, to amend your details, for us to delete your details, or just generally to engage or to subscribe, well, there you go. So colleagues, the ability of your data subjects to engage with you is not only a good practice, but it is a legal obligation as well. So those are the 5 key performance areas of your information officer. And of course, it's not an event, it's a journey. The next thing, and I'm not going to spend too much time on this, but is to just impress on you how broad and how deep the term personal information is. Firstly, colleagues, it's about an identifiable natural or juristic person. So this is where the GDPR is very different to our POPI Act, because the GDPR only looks at the European Union natural people, whereas South Africa's POPI Act goes a step further and says juristic people, companies, non-profit organizations are also legal personas whose information deserves to be protected. So your natural people like you and I, and then your juristic people. Paragraph A then says personal information includes, and obviously race, gender, sex, all those grounds that we've become so accustomed to, sexual orientation, belief, culture, language, and birth. It then extends to medical, financial, criminal, or employment history. And now we're getting into the world of TESs and workforce solutions businesses, because you are sitting on all of this information. You're doing credit, criminal reference checks. You're delving into the world of personal information. Even email addresses, physical addresses, identifiers, biometrics, personal opinions, correspondence that's of a private or confidential nature, views or opinions about people. And even if you don't put their name in clear lights, the point is, if you even disclose facts that can link those facts to a person without mentioning their name, that is also personal information. So, for example, if I said to you, do you remember we had a previous president who really struggled to articulate large numbers? You would know I'm talking about ex-President Jacob Zuma. So I don't need to say it's Jacob Zuma, the ex-president. If I say to you there was someone who held a senior office in Parliament, in government, who battled to articulate large numbers, then you'd know who I'm speaking about. So don't think it's just about putting the person's name. Even if you disclose factors that can link them to something, then that could be personal information. And obviously, colleagues, if it's already in public domain, then it's not personal information in terms of you can still obviously process it because it's already in the public domain. But if it's not in the public domain, well, then you've got to be exceptionally careful. So I really just challenged you to say, think of the key business processes where you process personal information in your organization. So what does processing mean? Well, it's collecting and receiving information. So CVs, timesheets, medical results, test results, assessments, any form of personal information that you receive. You then store it and collate it. Sometimes you store hard copies, sometimes it's digital copies, but the point is you're storing this. You're storing it in the cloud, you're storing it with Metrofile, you're storing it in your cabinets, and you're storing it wherever it is, even things on your desk. If I look at my desk right now, I've got personal information. I've got some client information on the side here, and I've got some staff information. And now when I leave my desk, what do I do with that information? Do I lock it away? Do I secure it? You then disseminate information. In other words, you send it places. You send information about your candidates and your assignees to your clients. You use credit bureaus. You use educational qualification verification services. You do work with auditing firms and BE verification companies. So you're disseminating information all the time. You're merging and linking information. So you've got different systems. You've got systems of record, systems of integration, systems of application, and these systems are continuously interconnecting, and you're merging and linking information. And then ultimately, the last part of the data life cycle is de-identification and destruction. And that is, for me, where companies are performing the worst. So the lawful processing of personal information is clearly defined, colleagues, and we don't have time today to go into all 8 of these areas, but just remember these 8 principles. If ever you are unsure as to whether or not you are lawfully processing information, ask yourself the following. Do we have a culture of accountability in our organization? In other words, before an employee attaches an Excel spreadsheet with personal information and sends it off, is it password protected? In other words, is there a culture that when I leave my desk, I secure this information and I ensure that it's safe? Secondly, do I ensure that we limit the processing of information to that which is legally justifiable? And I'm going to share 4 justifiable reasons for processing information with you in a minute. The next one, do you use personal information solely for the purpose for which it was collected in the first place? So if you get candidate information in order to place them with clients, you cannot use that information for other purposes. You can't use that information and sell it as data to research businesses. You can't use that information without the data subject consent and, send it to third parties that has no relation to why you collected it in the first place. Then the fourth one is further processing. So it's not as if you receive this information and collect it and store it and then sit on it and keep it. You continuously further processing it. You're disseminating it. You're doing reference checks. You're doing credit checks. You're doing criminal checks. You're doing license verification checks. Sometimes you do medicals. You do polygraph tests. You're doing all of these things. And that means you're processing it beyond your boundaries. And we're going to see just now that you are responsible to a large extent for ensuring that that is done in a manner that complies with POPI. The quality of your information has to be up to date, and that's another reason your data subject should be able to get hold of you. You need to be transparent and open. In other words, your privacy policy needs to be clear and say, in our TES, we collect the following information, and then you got to list it. From the following data subjects, list the data subjects, and then tell them what you do with that information. Tell them how you process it. Tell them how you ensure the security of that. Do you send it offshore? Do you have operators that you forward it to for further processing? You see, colleagues, you need to be transparent and open and tell them what you're going to be doing with the information. You then need your IT propeller heads to give you security safeguards. You need to be sure that your security is up to date. And then finally, as we said, your data subjects need to be able to participate in their information. Now, data subjects have got significant rights, colleagues. And I'm quickly going to go through this, but data subjects have the right to be notified when you are collecting their personal information. And that's very important. You know, they have to be aware and notified of that. And they have the right not to have their personal information compromised by having unauthorized people accessing it. Your data subjects, as I've spent time sharing with you, can also request access to the information. They can ask you, I want disclosure on what information of mine you have. I want you to correct, destroy, or delete that information. They can object to your marketing. So you need to have opt-outs on your marketing, your electronic marketing brochures. These data subjects have got significant rights. Now, colleagues, I've put a big important sticker here. So if you've nodded off and you're busy answering emails, I really want you to come back just for a few minutes. You see, colleagues, I'm often asked, John, are we allowed to process this kind of information or that kind of information? And I use this on the screen as my beacon to orientate my answer. So let's use an example. You get a phone call from a bank, let's say Standard Bank. And Standard Bank phone Albie, right? And they say to Albie, listen, Kevin Cowley, our good colleague, Kevin Cowley wants to buy a house. We need you to verify Kevin's employment. We need to know his job title, how long he's been there, his monthly earnings, and so on and so forth. And the question is Albie allowed to disclose that information in respect of Kevin to the bank? You know, and you can think of 100 other scenarios. Are you allowed to disclose the results of a cannabis test to your client? For example, is your client allowed to process information? So let's take a look at this. The first question always is, have you got consent? In other words, did Kevin consent to you disclosing personal information to the bank or any other party? And how would we know? Well, we would ask him, right? We'd go to him and say, Kevin, we've got this request. Would you mind if we disclosed it? And he'd say he knows nothing about it, or yes, go ahead, you may do that. Let's say that that's not possible. The next one is there a contract between the TES and the employee? That contract must be in the form of a clause in your employment contract or a policy. Colleagues, you need to have clauses in your employment contracts that say, by virtue of your employment with you as the TES, that employee gives you the authorization to process their personal information, not only internally, but also to third parties that may be required. Okay? So it's a very important requirement. Even after employees leave your employ, they should have agreed for you to give references on them. So your employment contract should contain a waiver of privacy in respect of you as the employer being allowed to process personal information of your employees, not only internally, but to third parties. So if Kevin has signed that contract, well, then it's fine. Then you can disclose that information. If neither consent nor contract apply, the third question that I'd ask is it a legal obligation to disclose? In other words, when it's employment equity reporting season, you don't see, employers running around to their employees and saying, please, can we disclose your race or your gender or your disability status? No, It's a legal requirement to submit your EA2 and 4. It's a legal requirement to get an EEA1 form. It's a legal requirement to submit tax. It's a legal requirement to do all of these things. So if law requires it, you don't need permission. Okay. The fourth one, you may also process information of the data subject if it is in their legitimate interest. In other words, if it truly is going to be to their advantage and not prejudice them in any way. The next one is enforcement of law in the public domain. So in other words, if you are being investigated for criminal allegations, you're not going to have the police services asking if they can go and check out your records. They're just going to do it because it's part of the enforcement of public laws. So colleagues, that is very, very important. And I would highly recommend that when you train your staff, when you train your assignees and you create awareness, use this as the point of reference in terms of answering whether or not you are allowed to disclose information. The next section I'm going to touch on very briefly, but it talks about retention of information. And what they're saying here is personal information must be collected for a specific, explicitly defined and lawful purpose. And then it says records may not be retained for any longer than is necessary unless it's required by law or the responsible party requires it for lawful purposes, or the retention is required in terms of a contract between the parties, or the data subject has consented. And if we take a look at your environment, and this is just a little snapshot, think of all the laws that apply to you as a TES. You've got the Companies Act, you've got Consumer Protection, the Credit Act, you've got COIDA, and Kevin is a custodian of that for business. You've got OSH Act, you've got Insolvency Act, BCA, Employment Equity, UIF, income tax. You've got all of these acts and a lot more that I haven't even listed. And each one of these have got a legal requirement. So the OSH Act's 40 years that you need to retain personal information on your data subjects if it's got to do with health and safety. But if it has got to do with basic conditions, it's generally 3 years. And if it's the Employment Equity Act, it's 5 years. Now think of your job applicants, colleagues. All your job applicants. An applicant for employment is deemed to be an employee under which act? Well, it's under the Employment Equity Act. Now you're sitting potentially with job application forms from tens of thousands of people from 20 or 30 years ago. And the more information you're sitting on, the more dangerous it is because that information can be more easily compromised. So I think what I'm saying to you today is, what is your data retention policy? How do you deal with the destruction or the de-identification of personal information? Now we move on to further processing. In other words, sending people's information to third parties. So you send your assignee information to your client, or you do a credit check or criminal check, or you run a payroll and you send information to the banks, whatever the case may be. And further processing is very similar in that it has to be consented to by the data subject. So the job applicant or the TES assignee must then have consented, either in a contract of employment or in a specific consent form that you would have used in order to process that. Obviously, colleagues, if it's a public record, then you don't need consent. So if people have put themselves out on LinkedIn, people have put themselves out on Facebook and Instagram and TikTok and who knows what not, if they've published their personal information, well, then it's in the public domain. Then you can process that. As I said, you can process that information to maintain law, or you can use it for historical, statistical, or research purposes. Now, I want to talk to you briefly about the privacy policy. You see, colleagues, the POPI Act says each responsible party, that's a TES in your case, must maintain documentation, and that documentation must allow the data subject to be aware of the information being collected, where it is being collected from, what information they are collecting, the name and address of the TES, the purpose for the information, and so on and so forth. So it falls under the transparency of what you do with information. And just to illustrate the importance of this, I'm going to use the Zoom privacy policy. And I hope that each and every one of you have got a privacy policy on your website that all your data subjects are referred to when you transact with them. So I remember during COVID-19, when we first subscribed to Zoom, we had to accept their privacy policy. Because the privacy policy, first of all, tells me as a data subject to Zoom what personal data they collect. So they actually tell you, we collect your bank account details, we look at how often you use Zoom, we look at how long you use Zoom for, we look at the number of people on Zoom, etc. So they tell me what data they collect. They tell me how they use that data. They actually tell you that they sell your data to marketing and research companies. They tell you how they share data. In other words, how do they transmit it? You know, what systems do they use? Who can see and share your data? What about people under the age of 18? How do we contact Zoom if we want to engage with them on our data? How long do they retain it for? And so on and so forth. So by contracting with Zoom, I can't come back to them later on and say, well, yes, I didn't know you sell my personal information to marketing firms. I'm getting phoned by marketing firms morning, afternoon, and evening. You see, I can't then say as a data subject I didn't know because they referred me to this. In the same way, your signees, your candidates, your clients, your suppliers, you need to refer them to your privacy policy so that they cannot come back later on and come and complain about it. The next thing I want to talk about, colleagues, is what I call security safeguards for further processing. And I want you to please look at this. The POPI Act says the following, and this is verbatim. Look at this yellow highlighted area. A responsible party, in other words, the TES, must, in terms of a written contract, ensure that the operator which processes personal information for the responsible party establishes and maintains security measures referred to. So let's stop there. At first, he says, if you use an operator, you need to have a written contract with them, and that contract must ensure that the operator establishes and maintains all the POPI security measures. Now, if you look at the diagram on the right-hand side, the responsible party in the orange circle is you, the TES. So in other words, you, the organization that is receiving personal information from candidates, assignees, clients, suppliers, etc. And because you're receiving that information from these data subjects, you are responsible for POPI. They're saying some relationships that you have as a TES are not just with normal suppliers or normal third parties. It's different because you use them as operators. In other words, they receive your data and data subject information from you to perform a particular function. You need to put that agreement in writing because it doesn't help if you go to all this trouble, you become compliant with POPI in your orange circle, and then you then send information to a third party, but they haven't done the same, and then your information gets compromised. So An operator, we will get to the definition just now, but for purposes of illustration, when you send a job applicant's information to do credit, criminal, or criminal checks, that third party that you send it to is an operator, because they're taking your data subject's information, they're processing it in their environment, and you therefore need to ensure that they are compliant with POPI. And that must be a written contract. And if the operator, let's say, for example, the bureau you use for credit and criminal checks, if they get hacked, they've got to notify you immediately if there are reasonable grounds to believe that the personal information of your data subjects have been compromised. Because if that has, well, then you've got to, as you see at the bottom of the slide, notify the regulator, notify the data subjects, and it even tells you how to do that. You've got to mail the data subject, you've got to email them, you've got to put it on your website, maybe publish it in the media, and the regulator might even require you to go further than that. So, colleagues, one of the big responsibilities is to ensure that you as a company have got all operators tied up in written agreements. Of course, you've got to put security safeguards in place, and we touched on those safeguards in terms of technology and operational safeguards. And then if you send information outside of South Africa's borders, so maybe you are a supplier to a multinational and some of your data subjects information ends offshore, or if you maybe transmit information on your data subjects outside of South Africa's borders, you have to ensure that the country that is receiving the information has got legislation at least of the same level of protection as POPI in South Africa. So let's take a look, colleagues. It's been a bit of a theoretical exercise, but let's just backtrack. We looked at the world in which we live, and we said, the world in which we live changes so rapidly. We change technologies, we change systems, and because everything's integrated, if something goes wrong, we're in a lot of trouble. Then we've now looked at the core POPI principles. We looked at the definition of personal information. We looked at the framework of the TES, the need to be proactive, secure, conscious, as well as when something happens to respond appropriately. We've taken a look at the role of the information officer and the issue around operators and data subjects participating in their information. In drawing this to some form of conclusion before we open up to discussion or Q&A, I now want to bring it a bit closer into the world of the TES. So let's just take a look at what's happening. The TES, colleagues, is the responsible party, right? Why? Because it is receiving information on data subjects. These parties on the left-hand side, remember, they're both natural persons and juristic persons or legal entities. So you're sitting with the banking details of your suppliers, you're sitting with your clients' details, registration numbers, you're sitting with your candidates' information, etc. So you're sitting on this mountain of personal information. You are responsible because you collect it, you store it, you disseminate or transmit that, you merge it, and you de-identify it. So this life cycle of data is your responsibility, and you must ensure it is characterized by integrity and security. When you engage in transactions, you've got two dimensions. You've got general processing. In other words, general processing is, let me give you an example. Today, I am going to invoice you as Global Business Solutions. I'm going to invoice your company for my services. What do? I send you an invoice. It's got Global Business Solutions banking details, my contact details, the description of what was done, and the amount that you owe me. Now, in that context, with you just paying an invoice, that's not an operator agreement. That's purely a transaction of you paying my account. It's paying my invoice. When you transmit salaries to banks to pay your hundreds of thousands of assignees, that is not an operator agreement. It's merely a transaction for you to pay your assignees. That does not require a written agreement around an operator, but some transactions fall within the scope of operator agreements where we need to have a written legal agreement. And on the next slide, I'm going to unpack that. All of this is then underpinned by the requirement to have important documents in place. The first one is your general privacy policy. Colleagues, just like the Zoom policy that I showed you, or our global business solutions policy, your privacy policy is critical, and you need to bring it to the attention of your data subjects all the time. Your privacy policy needs to be on your website. I would highly recommend you refer to it on the footers of your emails, your vendor forms, your application forms for your candidates, because you want to tell all your data subjects here on the left-hand side, you want to tell them all that by virtue of them transacting with you, they agree to your privacy policy, because it's that policy which discloses what information you're collecting, how you're collecting it, who you're transferring it to, and how long you're keeping it. The next document is your client SLA. You know, I remember in 2015 when Kevin and I and Johnny and, a whole range of colleagues were negotiating the amendments to the LRA. I remember we spent a huge amount of time saying, how do we now contract with clients in SLAs? Who's responsible for chairing a disciplinary? Who's responsible for reporting on TES assignees for employment equity? Who's responsible for COIDA claims? So we spent a lot of time updating our SLAs around labor law. Well, the same must happen about POPI. Your SLAs with your clients need very clear appropriation of responsibility and liability around POPI. Your employment contract with your assignees, and I touched on this earlier, you need to have a structured clause that does two things. The first thing, your fixed term contract with your assignees and your permanent staff must specify that they give you permission to process your personal information within the purposes of your employment contract, as well as to disclose that to third parties, to do reference checks, to do credit checks, to do criminal checks, to pay their salaries, to do reference checks and provide references after they've left. The second component is that they themselves will comply with your and your client's POPI policies. The next one is your operator agreements, and then the final one is your Promotion of Access to Information Act manual. So for me, those are the 5 most important documents that you need to have in place as a TES in the context of POPI. In conclusion, let's talk about operators in your environment. An operator by law is defined or refers to a person, that's a natural person or a legal entity, that processes personal information on behalf of a TES. The responsible party, that's you, the TES, determines the purpose and means of processing, but the operator carries out the actual processing. So an operator is like a service provider or a subcontractor that handles personal information for you. So examples of an operator, and I thought I'd just get this, and I'd love you to type into the chat box. I'd love you to type in the chat box who you think are good examples of operators in the TES environment. To get you thinking, the first example of an operator is your cloud storage provider. So whoever provides you with cloud platforms and facilities for you to, store and access your information, that cloud storage provider has got all that personal information. And whilst you remain the responsible party, your service provider for cloud facilities would be an operator. If you outsource your payroll service, for example, so you take your timesheets and whatever else, you outsource it to a different business, they run it, they would be an operator. Other ones I can think of would be when you do verification checks, when you do work with your BE verification agencies, maybe auditing firms who, take samples of your information into their environment and process it to give you a certain output. Why am I highlighting this? Well, colleagues, because you have to have a written operator agreement. And that operator agreement, I've just included some of the clauses that should be in such an agreement. That operator agreement must ensure that your operator complies with all the legal requirements that you would have to comply with yourself. So some final thoughts before I hand back to Albie to open up to questions. Here's some final thoughts. These were just things when I was preparing last night that came to mind. Do you have a bring your own device policy? So many people are working remotely. They're working on your client's premises. So many people are using their own devices, be it an external flash drive, their cell phones, an iPad, their laptop. Do you have a BYOD, bring your own device policy? Because that should be part of your policy document. Have you created an awareness, and are you creating an awareness of POPI across not only your permanent staff, but also your TES assignees, because it's a legal obligation? The next one, fixed-term contracts. Are your clauses in your fixed-term contracts inclusive of POPI and your rights and your assignee obligations in that regard? Do your service level agreements properly address your relationship with your client? I want to suggest to you, colleagues, in my personal view, and you'll see I've just snuck it in at the bottom right-hand side here on slide 29. I believe your clients are operators in your world, because you are sending your clients personal information of your candidates, your assignees, and your clients are using that information, whether it's for access control, whatever it is, to issue PPE. The point is your clients are processing personal information, and I would highly recommend in your SLA that your clients accept that they are operators in the context of POPI. Have you also included the Cybercrimes Act in your policies? Promotion of equality and prevention of unfair discrimination. Do you destroy data when it is legally no longer required to use it? Have you updated your disciplinary codes, colleagues? Sometimes I look at these disciplinary codes, it looks like they've fallen off Noah's Ark, because they are so stuck in the third industrial revolution. There's no specifics around harassment. There's no specifics around a breach of POPI. There are no specifics in terms of cybercrimes. There are no specifics in terms of cannabis. So you've got all these new laws and regulations coming through, but our disciplinary codes are still stuck in the past. Well, colleagues, that brings me to the end of the formal part of the presentation. I hope I haven't bored you to absolute death, but I do hope that I've given you a bit more context and at least challenged you to revisit and to take a fresh look at how you stack up. Albie, over to you. Thank you.
Thanks, John. Once again, very insightful. And yeah, I think there's a lot of food for thought that needs to go into what we have in place and just double check ourselves again. Just a question from my side when you start talking about the operators, etc. So yes, we do use verification companies to do certain verifications. In the absence of a pure SLA with that company, there's always a consent form that the person needs to complete. So I will send a form to you. I want to verify your BCom honors degree. You fill in your details in there, and that's on the letterhead of the verification agency that we use, and therefore you give consent that we may access or they may access. Would that suffice if there is not an SLA in place?
LB, it would suffice insofar as, remember, there are 4 grounds on which you can process: consent, contract, legal requirements, and then public law. So would I be able to submit the request with my consent? Absolutely. And I think that's why those bureaus have got those forms for you guys to sign and to have your data subject sign. The question is, do you also need to have an operator agreement with that verification agency? And as I said in my presentation, my personal view is that the answer is yes, because they're not just a normal transacting partner. They're actually taking that information into their environment, the ID number, the address, and their credentials. They're processing it, and they're using their systems and their protocols to give you an output. So LB, I would say that those types of suppliers would also need an operator agreement. And if they haven't yet got a standard agreement around operators that either you get them to sign or they get you to sign, I would be quite concerned about that. Because if your candidate's information is then, there's a cyber attack on one of the agencies you use, the first thing the regulator is going to say to you is, are they an operator as defined? And if yes, where's your written agreement with them? Because as soon as there's a breach, they've got to let you know. Because you've then got to get hold of the candidates whose information has been breached.
Yeah, no, that makes a hell of a lot of sense. And it's just, at the end of the day, all of those acts, etc., that you showed earlier, it just shows you the minefield that we have to go through to remain compliant with all of these acts.
And I think maybe just on that, I actually thought you were going to also touch on reference checks.
Yeah.
So Kevin Cowley leaves your employ, and then he comes to ABC Pty Limited, who want to employ him. And then they phone Albie and they say, Albie, listen, we've got Kevin who's looking for a job here. Give me a reference on Kevin. Would you re-employ him? How long did he work there? Was he always on time, etc.? And, the normal stuff. The question is, are you allowed to give Kevin's prospective new employer that information? And it comes down to those 4 questions again. Firstly, has Kevin give you consent? Secondly, did you, in your employment contract, when he was employed with you, get his consent that even after termination, you can still share his credentials with third parties, etc.? And I think it's so easy to fall foul of that, because you might go hell for leather and tell this new employer about Kevin. Meanwhile, he hasn't given you any consent or any contractual agreement to do that. He doesn't get the job, and then he has he gets the zigs with you, and then next minute he's taking you on with the regulator because he's saying, I didn't give consent to Albie to do that. Obviously, his CV might have said to the new employer, yes, these are the references, but does the CV actually say they could have contacted you? So it's a very, very important. I would rather get comprehensive agreement up front, so that once you've agreed, I can do everything.
Yeah, and so talking to that, so Kevin has now, he's come and he's applied, and we've interviewed him, and we've done all of his other checks, etc., etc. Now I pop an email to Kevin. I said to him, Kevin, on your CV, you have the following people, X, Y, Z of company Y. Can I do references? Please provide me with the authority to do that. Would that cover you in terms of that?
Absolutely. Absolutely. Either in terms of that, or if it's an online form that he completes, an asterisk. By completing this form, you accept all our privacy policy. Here's the link. And, then maybe your privacy policy is the actual point of departure. And in that privacy policy, you'd say, by virtue of our business as a TES, we do reference checks.
Yeah.
And by completing this, if you capture references, you're giving us permission to contact them, So I think you just got to look at your processes and how to best do that.
Right. I mean, the other side of it as well, apart from where you're sending the stuff, I mean, now you start looking at your medical stations and the information that they keep. It becomes all encompassing, and it's really something to think about and something to go and have a look at and see what is in place. Because I mean, by pure nature of our business, Koos needs 15 people in his warehouse, but they need to have a medical. We've got 15 people at the gate. We don't have a medical, and the first and the best medical station, we pop them in there. They supply them with their IDs, and off they go. Do a medical, and Bob's your uncle. But do you have an agreement with that medical station? The fact that the employee signed a form or whatever with that medical station, does that protect you? Those are all questions that you probably would have to ask.
So Albie, I mean, just think of this. So you then send your assignees' details to a client, and they do an on-site medical, maybe using their clinic or whatever, or their medical center on your client's premises. Your client then gets the results of the medical, but the person then leaves the LB's medical report on their desk, goes for coffee. Someone comes in, sees, here's the results of your assessments and your tests. Now you've got a breach.
Yeah.
But that happened in your client's environment, and that's why I think your clients are actually operators, because they're sitting with a huge amount of your assignees' information in their world. Now, if that happened, your client, at least you'd be able to show my client, was an operator. In the SLA, we covered that, and the client's then liable because the client warranted that it is fully compliant with POPI. But if you don't have that written operator agreement, I think you'd be vicariously liable for your client's delictual acts, which would be a big problem.
So here's another question. And sorry, guys, I mean, the rest of the people on the meeting, please feel free to ask. We often, and it's more in the white collar space as opposed to the blue collar space, but it is TES work. So you have clients and they say, well, we want 7 engineers. These are the specifications. Here is our portal that you need to upload that information onto. So I go out into the big wide world. I find John, Kevin, Lisa, whoever's CVs, and they all meet the criteria. They've signed all of my information, and we're happy. I feel I'm covered. All of my stuff is covered. Now I go and take that information and I put it into their system. Obviously, then there must be agreement that their system is also compliant, because it now becomes the operator.
Yeah, if they're going to be processing that information in their world,
Yeah.
So as I said, I just use the distinction. You paying my invoice, we're not operators. All you're doing is you're paying me for a simple transaction. But as soon as you take information into an environment where the other party processes it to achieve an outcome that's, you would normally have done, but they're doing it on your behalf, well, then you firmly in the operator space. I mean, just think of, for example, your BE verification agencies. They come and they take samples of learnership agreements, employment contracts. They, all of those things. They get information about beneficiaries of employment and enterprise development initiatives. So the reality, LB, is you need to really be on top of those operators. But yeah, it's a very interesting world. But at least once you've got the framework and the foundation, you can improve. But it's getting that foundation in place and then regularly revisiting it, because I can promise you now, in the last 6 months, you've used new systems and platforms that you didn't previously have. So unless you sit every quarter and say, okay, we've actually got a new CRM, and now we've also just used a new verification agency, and then we've got a new client and we've got a new system. And if you don't keep looking at that, you're going to get left behind, and they're going to be holes all over the place. So you actually need a bit of a committee to engage. Anyway, any questions?
Yeah, Lisa, go ahead.
Hi, Don. Yes, I've got a question. For example, like the Sasol shutdowns and Petra SA, where we know we mobilize quite a lot of people, and then we get the tandas or the timesheets from Sasol provided to the contractors who's our clients. So there's sometimes 3 or 4 parties involved. And I know from standard service level agreements between the TES companies and the contractors who is contracted to Sasol, there is no mentioning of that information regarding POPI in those agreements as well. Is there any guidance how that could be handled?
Yeah, that's Lisa. That's it's a good question, man, and that's exactly why I'm raising it, because the reality is commercial agreements and employment agreements are often lagging. Labor law and commercial law is lagging behind these new developments. The only way I would recommend you raise it, because also you don't want to alienate your clients, etc. But I would certainly at least correspond with clients and raise the fact that there's no provision for it, and refer them to the section of the POPI Act that specifically requires an operator. I mean, what you describe now, biometrics, timesheets, hours worked, medicals, all that kind of stuff, that is in the domain of operator, fairly and squarely, So I would try and maybe use it as a differentiator and send them an example of an operator agreement and say you really recommend they look at including this. Whether or not they give you time of day, of course, is a separate issue. But at least at the end of the day, you'd be able to pull that correspondence out and show the regulator, what, at least we tried. We made them aware of it.
So going forward, it would be a good thing to work in a clause like that into your new service level agreements when you renew and re-sign.
100%, Lisa, 100%. And I think POPI is a differentiator. I think if you can give your clients the peace of mind that you're on top of it and you cover all those bases, I think it's a big ticket item.
Kevin, you've got a question.
Thanks, LB, and yeah, Kevin Carley. I hope I got employed. But just going through the process. John,
that's cool, Kevin.
Just going back to when you and I actually became involved in the POPI, right? 2012. The issue of information officer was one of the matters that continued to fly a kite in terms of the negotiations we had with stakeholders at that stage, and it did progress to some extent because in terms of the presentation of today, there's a lot more clarity. But I think one of the issues that, with regard to the information officer, was that this is a new beast on the block, and so therefore, we can't really identify candidates of that nature. My question just is from a point of clarity. If we go back to KPIs and KPIs and creating a job profile for these people, I might be wrong, but I don't think anyone else has gone out there from the responsible delegated authorities to actually put something together, which previously was the case. When we were looking at the Employment Services Board, it was a different thing altogether in terms of that process of identifying parties. It looks to me too still the act is still a bit vague in that respect. John, so I just thought maybe some of your comments on that, maybe you can lend a little bit more clarity in terms of my dilemma.
Kevin, the good news is you were employed. You had a very good reference.
Bad news for the employer.
I'm not sure about that, man, but Kev, yeah, it's a very interesting question, and what's really insightful is, first of all, the information officer, as you know, defaults to the CEO, or the highest ranking officials. That CEO, as we know, can delegate responsibility one level down and appoint an IO or a deputy IO. And those 5 key performance areas that are touched on literally are verbatim, as you know, out of the POPI Act. Firstly, create a framework for compliance. Secondly, create awareness. Thirdly, have a PIO manual, etc. So those 5 KPAs are there. And what is quite interesting, and while you were talking, Kevin, I was thinking, colleagues, isn't it amazing, man? You've got to appoint an information officer. It's a statutory appointment. You've got to appoint an SDF. It's a statutory appointment. You've got to appoint a senior manager responsible for employment equity. It's a statutory appointment. Under the amendments to the COIDA Act, Kevin, and of course that's your world, amongst others, you're now going to have to appoint an employee health and wellness rep under the rehabilitation and reintegration rules. And now the 5th one is you've got to appoint a 16(2) health and safety rep. So literally off the top of my head, there are 5 statutory appointments. I mean, can you imagine? I reckon you need to start looking at maybe appointing one person in your company, and that's their full-time job to do all 5. They must be your SDF, your equity person, your IO, your section 16(2), etc. Because one day you're going to have so many people running around as statutory appointments, not going to do any work. And the other thing is they need the similar competencies. All of these people need project management expertise. They need to be able to do audits. They need to be able to report, etc. So I think the way legislation's going, and given these myriad of statutory appointments, I would seriously consider identifying one person and dumping it on their plate and giving them that governance obligation. It's just so important, but it's also, you don't want to burden too many people that it takes your eye off the business.
Yeah, no, that is a challenge. Just to speak to Lisa's point, John, I mean, normally clients, they give you an SLA and you will highlight this, so you've now covered your backside with an email, and that's fine. But they say, well, we're not interested in your problem. That's your problem. Keep it your problem. Could you, within your employment contract with the person, explain to him that certain data will be, your biometrics will be there, this. Would that also, to a certain extent, cover you, because you're making them aware that there is another party that's going to give us some of your information, and that will have some of your information?
Yeah, LB, I mean, it can't do any harm. The unfortunate thing is that, if it is an operator, then you got to have the written contract.
Yeah.
So you're going to have to, over time, and I think it's going to become more common. I think a lot of companies are a bit backward, but the more we deal with data and the more litigation there is, and the more the regulator starts conducting proper compliance audits, I think it's going to become the norm. Just like, as I said, the 2015 LRA amendments have become the norm now. We know what deeming means, and we know who can chair disciplinaries and who appears at the CCMA, and I just think it's going to be a process of education. Until you get there, LB, I think you need to do what you've suggested, because at least you can demonstrate, that you've done what you can.
Yeah, if you've got another question.
Yeah, sorry, John. The other one is, the reality is the environment that we work in as TES. Often we take a lot of the blame on behalf of the client. That's just as it is. That's whether you like it or not. You want the business, you want to keep the business. There's certain people in the business who are reckless. They happen to work for the clients, and you've got to cover for them. And we've seen this in practice already, in terms of the amendments concerning the LRA and the application, where the mini miners wheels hit the ground. How many times you sit with the client, you say, okay, well, we'll take this one, or are you going to go 50-50, or, you know, the whole story. They did polygraphs, and they relied so much on the polygraph that the reality is that when you got to the commissioner, he left the building laughing, you know.
Yeah.
So the issues, you know, where do we go? Because the reality is that, you know, it's we are between the two. We sit between what the law says, and we know exactly what the law says, and we want to apply it. We are good citizens, but we also have certain clients that are certainly not good citizens, or, you know, basically purport to be, but they're not. And obviously there's a business relationship, and so, you know, money talks. So, you know, we have that risk. I think more so in the instance of information gathering and information dissemination. You know, and even if one has a policy on this issue, the question really is how do we enforce this with our clients? I mean, do we educate the client? Is that what we have to do, or, you know, do you have any other you know, good tips in terms of this situation? Thanks, John. Thanks for a very good presentation.
Thanks, Kev. And yeah, as I said, I think it starts with client education. You know, maybe what we could do with the TSD's leadership permission, you know, maybe we could even put out a new part of your newsletter, Christo. I'm not sure if you have, but, you know, we could maybe start an advocacy process. But Kevin, if you really just wanted to slip it in and have it part of a deal, but not a deal breaker, you know, I would really recommend a clause in your SLA with a client, or when you do negotiate SLAs, rather than being in your face and saying, here's Annexure A, here's a whole new operator agreement, and if you don't do this, you're in trouble. Maybe in the interim, you know, maybe just a paragraph in your SLA that says to the client, by virtue of the nature of our relationship, you know, you're going to be sitting with a lot of personal information of our data subjects, and by virtue of this, you warrant that you compliant with POPI. You know, just as a starting point. And you know, I think it would be highly unlikely. It's just like vicarious liability under the Employment Equity Act for harassment. You know, if you can prove as a company you got a harassment policy, and you did awareness training, and you got a grievance procedure, you're not going to be vicariously liable for the delictual acts of your managers and your staff. And I think the same principle for POPI. You know, if you can prove you've done awareness training, you've got a clause in your SLA, you made your client aware of it, I would just ease it in there. I think the problem, as you say, Kev, is now suddenly you bring out like a 20-page operator agreement and you show to your client, they're going to run for the hills. You know, I think that would be a problem. But do the best you can, as you've always done, and I think you'll be fine. And again, just for interest's sake, LB colleagues, if you look at the regulator, when they have picked up non-compliance, they haven't gone and sort of thrown you in jail. You know, they give compliance orders, they give advice, and if you then ignore them, then they're going to take you on. And that's what the Department of Justice did. They said to the Department of Justice, when you got attacked, we told you, you need this kind of encryption in your system. You need to get the software. And they just ignored them. They just ignored him. I mean, you know what? Then you must take what comes.
Yeah. 100%. Again, John, thank you for all of the insights. Are there any other questions from the members present? All right, that's a cheap round, John. And thanks again, guys. And for those of you